Um, so that was just an incredible, national advocacy effort that, you talk to people who knew the people in their states. We couldn't have done that from Georgia. It was a team effort.
There is a big difference between arguing a case in the Supreme Court and arguing a case to a court of appeals. If you look at the form, they look the same. That you start out, you write lengthy briefs laying out for the court your position on all the issues, and then you got a short period of time to stand up in front of the court and elaborate on what you wrote and answer the questions they've got. But the difference isn't quite so obvious to somebody who hasn't lived with it. But when you have, there are two fundamental ways in which the Supreme Court is different from a court of appeals. The first is when you're in the Court of Appeals, the court's mission is to decide your case and to come to the just result in your case. And in that context, Olmstead was a wonderful case. Justice was clearly on the side of the plaintiffs. The law seemed to be clearly on the side of the plaintiffs. And they did, in fact, win the case in both of the lower courts. But the Supreme Court isn't there to decide the justice of the particular case. The Supreme Court takes very few cases each year. Thousands of people who lost in the lower courts try to bring their case to the Supreme Court. Supreme Court decides which cases it wants to hear. It chooses only about 75 or 80 cases a year out of those thousands of cases. And its criterion for selecting them is we need to clarify some area of the law in general. We're not that interested in the outcome of this particular case. We're interested in shaping the law so that all the lower courts and all the state courts will know what they're supposed to do in this area, which means that in the Supreme Court, you're not arguing just the merits of your own case. You have to be aware of all of the potential ramifications of this decision because you know that the court's going to be interested in that. You know that the questions they're going to be asking you are not about your case. They're going to be about, well, what would it mean if we were to go with you for, and then they'll give you a whole bunch of different other scenarios that are likely to arise in the future. And if you can't satisfy them that a ruling in your favor is going to be okay in all those other areas as well, they are going to be reluctant to decide in your favor. So that's one way in which the Supreme Court is different. Your whole focus is different. You've got to be worrying about their focus, which is the big haul, not just your case. The other difference is that you're going before 9 people who have very elaborate track records. They have decided hundreds, in many of the cases, thousands of cases. You've got, with respect to each of those justices, some considerable insight into how they approach these kinds of issues, even though they haven't had an issue just like this, where their predilections are. And your job is to get 5 of them to vote in your favor, which means, as is a common phrase, that when you're an advocate before the Supreme Court, you're counting to 5. You need 5 votes. Who are the 5 votes that I can get? What will I have to be arguing in order to get those votes? And that was particularly a problem with respect to the Olmstead case. First of all, this is a case where it was obvious the court was going to be divided. And it was also obvious that the 3 justices in the middle, if you will, were going to be the decisive votes in this case. And so all of the focus had to be on arguments that they would find sufficient basis for ruling in your favor. And that's where the concentration for both us and for the Justice Department, which was on our side in this case, both were focused on those 3 justices. 2, most importantly, because we thought getting the third of those 3 was going to be a long shot. But we had to get at least 2 of those 3 in order to have 5 votes.
And who were those 3 justices?
Those 3 justices were Justice Breyer, who is ordinarily regarded as a member of the liberal bloc on the court, but who is profoundly concerned with the practical implications of the rulings the court makes. And so whenever you're up there, you're arguing an issue that his heart is on your side. But you've got to persuade him how this is going to play out in the real world. He goes around the country in debates with Justice Scalia before lawyer groups and other groups about what the right philosophy is for a Supreme Court justice. And Scalia has this originalism philosophy, which everyone has heard about. Breyer's philosophy is, I want to make sure that what I do makes society a better place. So before I can decide a case in a particular outcome, I have to decide that in the long run, that outcome will make society better. And so we knew that for us, in this case, the problem was going to be answering all the worries that he was going to have about the implications of this ruling in our favor for other kinds of cases, not so much for ours. Secondly was Justice O'Connor, who in those days was generally regarded as the swing vote, a person who was truly in the middle. She, I would say, voted on, when the court was divided 5-4, and she was the decisive vote, I would say roughly a third to 40% of the time she was on the liberal side. The majority of the time she was on the conservative side. But there were certain areas of the law, she had a big heart, that you could have more hope that you could get her. And we thought this was a case where there was that hope. Happily, it turned out that way. The third was Justice Kennedy, who today is regarded as the swing vote on the court. But he's the swing vote on the court today because whenever the liberals do happen to get a fifth vote, he's the one they get, but they don't get him very often. He's on the conservative side about 80% of the time. And so back then, he was the sixth vote you would try to get. You only needed 5. And he had not, in disability cases prior to that time, been particularly friendly to the disability rights movement. And so we thought it was going to be a really hard slog to get his vote. We were focused more on Justices Breyer and O'Connor as our fourth and fifth votes.
So we went over to the court the day before the argument, and that's when I was just amazed at what I saw, which was the entire, those august steps up to the pillars were covered or filled with individuals in wheelchairs for the most part, and other people with disabilities, with placards and signs and chants. It was fabulous. And then they were there all night long, and when we got there in the morning for the argument, they were still there. And of course, by then, they were lined up to come in and see the argument. What dawned on me as I sat there was the justices are really getting it. You just thought, are they ever going to really understand what it means for a person to be locked up in a state hospital like Lois and Elaine? Their world must be so far away from what is happening to people locked up in Georgia. And so I remember getting this sense during that experience that somehow or other, thank goodness, these people had thought enough and had the capacity to understand the issue. And you could tell that from the way they kept challenging the Attorney General from Georgia by asking really pointed questions, showing that they were not too sympathetic with the state's argument.
The opinion of the court in number 98-536, Olmstead versus LC, will be announced by Justice Ginsburg.
This case concerns Title II of the Americans with Disabilities Act of 1990, a measure I will abbreviate as the ADA.
I can't remember the precise experience of finding it out, although I think somebody called me on the phone and then I figured out how to read it online. That's what I remember, because I remember reading it online and thinking, this is the most complicated, convoluted decision, because it was in 3 parts. There was the decision by Justice Ginsburg, which was great, although it had some language in it that at first I could hardly breathe because I was reading it. I was so excited, but I thought, I hope that's not too bad. And then there was the concurring part, which looked a little worse, and then there was the dissent. So to answer your question, my initial response was, it looks as if we sort of won. The sort of was Justice Ginsburg said, we agree that states cannot keep people in institutions unnecessarily, and that violates the ADA. But she said, I'm going to make that ruling qualified by three things. One, if staff agree that the person can live in a community setting, if the person's not opposed, and if the state can accommodate this person without fundamentally altering its system. So that is legalese to beat the band, because all you could immediately think of is courts are going to figure that out, over time. But what does it really mean today? Right at the beginning, we actually thought Georgia would do the right thing. And we thought, wow, they've been litigating this for almost 6 years. They lost, and now they're going to say, okay, Supreme Court, will do the right thing. But in fact, they did very little. And it was partly because of that part of Justice Ginsburg's decision that was wiggly enough, that looked as if, well, maybe if we just, show good intentions and as if we're sort of trying, that would be enough. And we won't really commit the funds necessary to move hundreds and actually thousands of people out of hospitals.
The name of this series that I co-authored with Alan Judd at the AJC was called Hidden Shame. And we spent a good part of a year investigating the state's mental hospitals, psychiatric hospitals, and the problems in them, and the fact that people were being not only mistreated physically, and they were in danger, of physical abuse, but also there were a lot of suspicious deaths in the hospitals. To me, I remember one case in Milledgeville when I visited with a family, and how the patient described having been beaten up in the hospital, and just that kind of development made me realize that this was, that patients weren't safe. What Alan and I found was these hospitals were overcrowded, understaffed, underfunded. And it was basically, when you have those kind of number problems, it was a recipe for disaster in terms of what was going to happen to the patients while they were there. The official response immediately was nothing. I mean, we were surprised by the silence from the agencies that were involved in the governor's office. But after a good bit of time, things started happening. After 3 or 4 months, the Department of Justice came and started an investigation. The state had its own task force looking into the problems, and they found problems that the same problems that we found, that people were dying unnecessarily. And also, the state had its own consulting team go out to the hospitals, and they basically corroborated what we found. And so at that point, the momentum, after months of our work, we had several articles talking about different aspects of problems in the facilities, whether it was just suspicious deaths over 100 over a 5-year period. We found abuse, physical abuse of patients dying, unnecessarily from that. We looked at the discharge data and how many of the patients were just simply being discharged, some to bus stations, convenience stores, but many of them to homeless shelters. And in this state, you're not going to get mental health treatment in a homeless shelter, unfortunately.
The Department of Justice had already been talking to the advocacy community, asking questions, gathering information. And that was part of the reason we felt like the Justice Department was really doing the right thing, was because they were talking to the people we knew the full story. And of course, for us, Olmstead was the key. It was not putting a Band-Aid on the hospitals that were overcrowded, where people were being mistreated. That was never going to be the solution. That was a 19th century solution for how to do this, and it totally defied Olmstead. What really had to happen was that you needed to build robust community supports so that you could provide that opportunity, that freedom, that independence for people while giving them the support that they needed in the community. And we felt like that's what the Justice Department was going to do. So we were crushed in January of 2000.